it seems to me that the first big hurdle of the prosecution would be jurisdiction. And there's been a lot of discussion of whether the Philippines is still under the jurisdiction because the investigation was authorized way after we have withdrawn, our the withdrawal has been made effective. What is your opinion on this issue?
So my opinion is that the chambers are getting it right, and we have a certain degree of ambiguity in the Rome Statute. Article 127 of the statute states that as long as there are proceedings sort of under consideration, the jurisdiction of the court remains attached. And so really the question here is, was the preliminary examination that started sufficient to keep the court's jurisdiction alive? Now, some judges in dissent looked at Article 12 of the statute and they said, well, but you have to actually be exercising your jurisdiction, and the preliminary examination phase isn't enough. And so under international law, we look at a treaty called the Vienna Convention on the Law of Treaties, and we say, okay, we have some ambiguity in the Rome Statute. How do we resolve this? We look at the text, we look at the context, we look at the object and purpose, and then we look at the Vienna Convention. We look at other sources of international law and the practice of other international courts. And uniformly, in all cases, the International Court of Justice, the Inter-American Court of Human Rights, and the ICC have concluded that unless there's a specific statutory bar, the rule is the court's jurisdiction remains attached so long as, in the ICC case, there were some proceedings that were opened and that the crimes were committed while the state was still a party to the Rome Statute. And both conditions are met in the Philippines case, and that's why they say there is continuing jurisdiction in the case. Obviously, that will be litigated, right?
Yeah.
But I think the courts have been getting it right.
I understand it's because like we were only the second party to withdraw from the ICC, and in Burundi's case, the chamber authorized the investigation within the withdrawal period. Are we novel in that sense? Is this why this is still an issue to this day? It's because it's the first time that this happened.
Well, I think, you can imagine a continuum situation, right? So you can't, absolutely, it would be impossible, I think, now to hold the Philippines under jurisdiction of the court for crimes that were committed after the withdrawal. Clearly, there's no jurisdiction, or even for crimes that were committed a long time ago that were not under preliminary examination. Clearly, there has to be some activity by the court in order to trigger the court's jurisdiction and make the withdrawal ineffective. It's true that Burundi is in a later stage. So Burundi, if you think of a continuum, right, the Philippines is probably at the beginning of the continuum. Burundi is probably well within the statutory situation. And the example I gave of, well, the crimes were committed before, but nothing was done, right? The referral, Article 15 communication happens today. Those crimes are clearly outside the window. So you have what I would say is a continuum. And I think this is within the continuum because the crimes were committed while the statute was in force, and the preliminary examination shows that they were under consideration by the court.